8 attorneys sat on one side of the courtroom, one sat on the other. The 8 wore suits that cost more than the one earned in a year. They had paralegals, assistants, rolling briefcases, and a communication strategist sitting in the gallery refreshing Twitter on her phone. The one had a legal pad and a cup of coffee from the gas station across the street. For 2 years, this is what the case looked like. A billionaire media mogul named Byron Frost, protected by a $10 million legal team, against a small black-owned production company that was 3 months from bankruptcy. Every motion the small company filed was buried. Every hearing was delayed. Every document request was blocked. The legal system was not broken. It was working exactly the way it was designed to work, for the man with more money. But what Byron Frost and his 8 attorneys did not know was that the plaintiff's 26-year-old son, a quiet kid named Luke Boyd, who mopped the floors of a law firm in downtown Atlanta, had overheard something he was never supposed to hear. A conversation between 2 attorneys about a sealed document. A document that Byron Frost's legal team had sworn under oath did not exist. Luke Boyd did not hire a lawyer. He did not make a phone call. He walked into the courthouse, filled out a single form, paid a $45 filing fee, and submitted a motion to compel. 1 piece of paper. 2 years of legal warfare. Over. Pause for 2 seconds and help me do something fun. Comment your city and country. I want to see how global this community really is, and I am looking for the 2 viewers watching the farthest apart today so I can pin the winner. Now back to the story, because things are about to get very interesting. 3 years before that courtroom moment, Julian Boyd sat in a conference room on the 34th floor of Frost Media Group's headquarters in Midtown Manhattan. He was 52 years old. He wore his best suit, a navy blue 2-button that Frankie had pressed that morning at 5 a.m. before he caught the train from their apartment in Flatbush, Brooklyn. Julian had spent 23 years building Boyd Creative, a small black-owned production company that made documentaries, branded content, and short films. He had 12 employees. He rented office space above a dry cleaner on Fulton Street. His work had aired on BET, PBS, and 3 streaming platforms. He was not rich, he was not famous, but he was respected, and his clients came back. 6 months ago, Julian had developed a concept for a docuseries. It was called Invisible Labor, a 6-part series profiling the unseen workers who keep American institutions running. Hospital janitors, school bus drivers, overnight warehouse packers, hotel laundry crews. He had a sizzle reel. He had a budget. He had 3 subjects already filmed. It was his best work. His agent got him a pitch meeting at Frost Media Group, the largest independent media company in the country. Frost Media was worth $3.8 billion. Its founder, Byron Frost, had built the company from a single cable channel into a content empire. Streaming, podcasting, live events, and licensing deals across 4 continents. Julian walked into that conference room with his hard drive, his pitch deck, and his sizzle reel. He presented to 3 development executives. They watched the full reel. They asked questions. They took notes. They told him they loved the concept. They said they would follow up. They never followed up. Julian called twice, emailed 3 times. His agent called. No response. After 6 weeks, Julian moved on. He pitched the series elsewhere. A smaller platform picked it up. He began production. Then, 4 months later, Frost Media Group announced a new original docuseries. It was called The Unseen. 6 episodes, profiling the invisible workers who keep American institutions running. Hospital janitors, school bus drivers, warehouse packers, hotel laundry crews, same subjects, same structure, same visual style, even the same opening narration device, a wide shot of an empty building at 5 a.m. before the workers arrive. Julian watched the trailer on his phone at the kitchen table. Frankie was standing behind him. Neither of them spoke for a full minute. "They stole it," Julian said. "I know," Frankie said. "What are we going to do?" "I'm going to call a lawyer." Subscribe now and stay to the end because I'm going to show you one sealed document that Byron Frost's legal team swore did not exist. And when you see what was on it, you will understand why they spent $10 million trying to make sure nobody ever read it. This is not drama, this is exposure, and we are about to break down exactly how they buried it, step by step. Julian hired Jason Stewart, a 38-year-old intellectual property attorney who operated a 3-person firm in downtown Atlanta. Jason had handled copyright disputes for musicians and independent filmmakers. He had never gone up against a $3.8 billion media company. He filed the lawsuit, Boyd Creative LLC versus Frost Media Group. The claim? Copyright infringement, misappropriation of intellectual property, and unjust enrichment. Julian's pitch deck, sizzle reel, and the dated hard drive were the core evidence, time-stamped months before Frost Media's production began. Byron Frost's response was not legal. It was financial. He hired Gareth Sands, a litigation partner at one of the largest firms in New York. Gareth brought 7 associate attorneys. Their combined billing rate exceeded $14,000 per hour. Their strategy was simple. Don't fight the case, bury it. In the first 6 months, Gareth's team filed 23 motions. Motions to dismiss, motions to transfer venue, motions to compel arbitration, motions to limit discovery, motions to seal, motions to exclude the sizzle reel as evidence. Each motion required Jason Stewart to respond, research, brief, and argue, work that consumed weeks and cost money Julian didn't have. Jason did the math. At the rate Frost's team was filing, Julian would be bankrupt before the case ever reached trial. They're not trying to win, Jason told Julian. They're trying to make it too expensive for you to keep going. Can we stop it? I can fight every motion, but every motion costs us time and money, and they have more of both. Julian mortgaged the Flatbush apartment. Frankie took a second job. They pulled Luke out of community college because they couldn't afford the tuition and the legal fees at the same time. Luke was 24 at the time. He didn't argue. He didn't complain. He said, "I'll find work. You fight the case." He got a job as a janitor at the law firm of Whitfield, Burke and Associates in downtown Atlanta. He mopped floors. He emptied trash. He cleaned conference rooms. He worked the night shift, 7 p.m. to 3 a.m., 6 days a week. Luke Boyd had been mopping floors at Whitfield Burke for 14 months when the conversation happened. It was a Thursday night, 11:40 p.m. The office was mostly empty. Luke was cleaning conference room B on the 12th floor. The door to conference room A, next door, was cracked open. 2 attorneys were inside, Tim Bates, a senior partner, and an associate Luke didn't recognize. They were reviewing files. Their voices carried through the shared wall. Luke didn't mean to listen. He was pushing a mop bucket through the hallway. But Tim Bates's voice was loud, and one word made Luke stop moving. Frost. Luke stood still, mop handle in his fist. The Boyd pitch meeting was recorded, Tim said. Internal conference room camera. Frost Media records every pitch session for their legal archive. The recording shows their development team watching the full sizzle reel and discussing it for 20 minutes after Boyd left. "Where's the recording now?" the associate asked. "Sealed." Frost's in-house counsel flagged it during litigation hold and moved it to a restricted server. It was never produced in discovery. Gareth Sands knows it exists. His team filed a certification to the court stating that all responsive documents had been produced. That certification is false. That's spoliation. It's worse than spoliation. It's perjury. They signed a declaration under oath. Why are we talking about this? Because Frost Media is our client too. Separate matter, but I saw the filing cross-referenced in our conflict check system. The document ID popped up. I flagged it internally 2 months ago. Nobody responded. Luke did not move. He did not breathe. He stood in the hallway holding a mop, listening to 2 lawyers describe the one piece of evidence that could save his father's company. A recording that proved Byron Frost watched the pitch, discussed it, and then built an identical show. A recording that his father's lawyer had asked for in discovery and was told, under oath, didn't exist. Luke finished his shift. He clocked out at 3 a.m. He sat in his car in the parking deck for 45 minutes. Then he drove to his parents' apartment. Julian was at the kitchen table, surrounded by legal documents. He looked like a man who hadn't slept in weeks, because he hadn't. "Dad," Luke said, "I need to tell you something. Real quick, pause and drop a comment below. Tell me if you have ever been in a situation where you knew something was wrong, but were told to stay silent. Share your thoughts, because this community is built on people who refuse to look away." Luke did not call a lawyer. He did not go through Jason Stewart. He didn't have time. Frost's team had filed a motion for summary judgment, a request to end the case without a trial. If the judge granted it, it was over. Julian would lose. The hearing was in 9 days. Luke went to the Fulton County Courthouse the next morning. He was still wearing his work boots. He had grease on his hands from changing a light fixture at 1 a.m. He walked to the clerk's office and asked for a form. "What kind of filing?" the clerk asked. "A motion to compel production of a document." "Are you an attorney?" "No, ma'am. I'm a party in interest. My father is the plaintiff. I'm filing on behalf of his company as an authorized representative." He held up a notarized letter Julian had signed that morning, authorizing Luke to file motions on behalf of Boyd Creative LLC. The clerk took the letter, reviewed it, and handed him the form. Luke sat in the hallway and filled it out in pencil first, then rewrote it in pen. His handwriting was clean, the same careful lettering he had learned in a community college English class before he dropped out. The motion was 3 pages. It stated that the defendant, Frost Media Group, had failed to produce a recorded video of the plaintiff's pitch meeting, captured by the defendant's own internal conference room camera system. It stated that the recording had been flagged during litigation hold by Frost Media's in-house counsel and moved to a restricted server. It stated that the defendant's discovery certification, a sworn declaration that all responsive documents had been produced, was false. Luke cited 2 rules. Federal Rule of Civil Procedure 37A, which governs motions to compel, and Rule 37B, which governs sanctions for discovery abuse, including adverse inference, evidentiary exclusion, and default judgment. He didn't learn these rules in law school. He learned them by reading his father's legal filings at the kitchen table every night for 2 years, while Julian and Jason Stewart debated strategy, and Luke mopped floors during the day. He paid the $45 filing fee with cash. He submitted the motion. He walked out of the courthouse and called his father. "It's filed," Luke said. "You sure about this?" "I'm sure." Julian paused. "If they find out you work at Whitfield Burke, they will. You'll lose your job. Dad, you mortgaged the apartment. Mom is working 2 jobs. I dropped out of school. I've been mopping floors for 14 months so you could keep fighting. This is me fighting." If you love your mom, you need to subscribe right now, because at the end of this video, I am revealing one secret that nobody in that courtroom understood. There is a reason Byron Frost's lead attorney went completely silent when the judge read Luke's motion out loud. And when I show you the one sentence that broke him, you will realize this case was over before the hearing even started. Trust me, the secret is worth it. Judge Peter Harris read the motion in chambers. He was 63 years old, had been a federal judge for 19 years, and had a reputation for 2 things: hating discovery abuse and hating liars. He scheduled an emergency hearing for the following Tuesday. He ordered Gareth Sands to appear in person. The courtroom was half full. Julian sat at the plaintiff's table with Jason Stewart. Luke sat in the gallery behind them, in the same work boots he had worn to the courthouse. Byron Frost did not attend. He sent his wall. Gareth Sands and 3 associates, rolling briefcases, laptops, and a stack of binders that took up the entire defense table. Judge Harris entered. He did not make small talk. "Mr. Sands, I have before me a motion to compel filed by an authorized representative of the plaintiff. The motion alleges that your client failed to produce a recorded video of the plaintiff's pitch meeting, that this recording was identified during litigation hold, moved to a restricted server, and deliberately excluded from discovery production. It further alleges that your discovery certification, signed under oath, is false. He looked up from the paper. Mr. Sands, does this recording exist? This was the moment. One question, yes or no. In front of a federal judge who hated liars. Gareth Sands stood. He buttoned his jacket. He was calm. The kind of calm that comes from billing $1,200 an hour for 2 decades. Your Honor, we will need time to investigate the claim. The motion was filed by a non-attorney and the motion was filed by an authorized representative of a party, which is permitted under the federal rules. I'm not asking about the filing. I'm asking about the recording. Does it exist? Gareth paused. Your Honor, we are not presently aware of. Mr. Sands. Judge Harris removed his glasses. I'm going to ask you one more time, and I want you to understand that your answer will be compared against the forensic audit I've already ordered on Frost Media's document management system. The audit begins tomorrow, so I'll ask again, does the recording exist? The courtroom was silent. Luke's hands were pressed flat against his knees. Julian was staring at the table. Jason Stewart wasn't breathing. Gareth Sands looked at his associate. The associate shook his head, barely, almost invisibly. Don't. Gareth turned back to the judge. Your Honor, upon reflection, it is possible that certain media assets from the plaintiff's pitch session may exist in an archived format that was not included in our production review. Is that a yes? It is a qualified acknowledgement that additional material may exist. Judge Harris put his glasses back on. Mr. Sands, I've been on this bench for 19 years. In that time, I have heard every variation of I don't recall, I'm not presently aware, and upon reflection. Let me translate what you just said into plain English. You knew the recording existed. Your team certified under oath that all documents had been produced. That certification was false, and now, in front of this court, you are attempting to recharacterize perjury as an archival oversight. He leaned forward. Motion to compel is granted. The recording will be produced to the plaintiff within 48 hours. Additionally, I am referring this matter to the court's disciplinary committee for investigation of potential sanctions under Rule 37B, including adverse inference, fee shifting, and referral to the bar for potential disbarment proceedings. He looked at Gareth. Mr. Sands, you should call your client. He's going to need a different attorney, because you may need one yourself. The recording arrived at Jason Stewart's office 2 days later on a sealed USB drive delivered by a federal court officer. Jason, Julian, and Luke watched it together on a laptop in the small conference room above the dry cleaner on Fulton Street. The video was 47 minutes long. It showed Byron Frost's 3 development executives sitting in the conference room after Julian left. Julian had been in the room for 22 minutes. The executives stayed for 25 more. The first executive spoke. That's one of the strongest pitch decks I've seen this year. The invisible labor concept is fully formed. The budget is tight but realistic. The second, the sizzle reel is broadcast quality. He's already shot 3 segments. We could go straight to production. The third, my concern is margin. An independent producer with existing footage means we'd owe him a creator credit, back-end points, and co-production rights. If we pass on the pitch and develop an identical concept internally, we own 100%. The first executive again. Byron won't care about the optics. He'll care about the margin. The second. So we're rejecting the pitch? The third. We're declining the pitch and fast-tracking an internal version. Same concept. Different title. New host. We never reference his materials. Legal handles the paper trail. Julian stopped the video. He sat with his hands flat on the table. His jaw was tight. His eyes were wet. He had just watched 3 people decide to steal his life's work, calmly, methodically, while sitting in leather chairs and drinking coffee he probably made for them. "They didn't even hesitate," he said. "No," Jason replied, "they didn't." Luke said nothing. He looked at his father, the man who had spent 23 years building a company, who had mortgaged his home, who had let his son drop out of school, and understood for the first time what it costs to be right when the other side has $10 million and you have a cup of gas station coffee. If you are still watching, you are exactly the kind of person this channel was built for. Hit that subscribe button so you do not miss the next episode, because this exact pattern of corporate intellectual property theft and legal revenge shows up in another billionaire media case I am covering soon. And the one-paper strategy Luke uses here becomes even more important in that story. Jason Stewart filed a renewed motion for summary judgment, this time in the plaintiff's favor. He attached the recording as Exhibit A. He attached Gareth Sands' original discovery certification, the one signed under oath stating all documents had been produced, as Exhibit B. Judge Peter Harris granted the motion. He ruled that Frost Media Group had engaged in willful spoliation of evidence, had submitted a fraudulent discovery certification, and had acted in bad faith throughout the litigation. He imposed sanctions under Rule 37B, an adverse inference instruction to the jury, meaning the jury would be told to assume the concealed evidence was harmful to the defendant. He awarded Julian Boyd $340,000 in attorney's fees to be paid by Frost Media. Then he set the damages trial. It lasted 2 days. The jury deliberated for 4 hours. They awarded Julian Boyd $8.4 million in compensatory damages and $14 million in punitive damages. Total, $22.4 million. But here is the detail I told you to wait for, the secret that nobody in that courtroom understood at the time. Byron Frost did not attend the damages trial. His attorneys said he was traveling internationally. The truth was different. 3 days before the trial, Byron Frost had been contacted by the Department of Justice. The fraudulent discovery certification, the one Gareth Sands signed, had triggered a federal investigation into Frost Media's litigation practices across multiple cases. Investigators found that Frost Media had used the same strategy, withholding documents, filing false certifications, burying plaintiffs in procedural motions, in 11 other intellectual property disputes over the previous 7 years. 8 of those disputes involved small, minority-owned production companies. 5 had been forced to settle for less than $50,000. 3 had gone bankrupt. Julian Boyd wasn't the first person Byron Frost stole from. He was the first one who didn't break. Gareth Sands was suspended from the bar pending a disciplinary review. 2 of his associates resigned before the investigation reached them. Frost Media's stock dropped 19% in the week following the verdict. Byron Frost stepped down as CEO under pressure from the board. He was not arrested. He was not charged. Billionaires rarely are. But his company was diminished, his reputation was destroyed, and the name Frost became synonymous with the kind of corporate theft that only works when nobody fights back. Somebody fought back. A janitor's son with a $45 filing fee and 3 pages of handwriting. Julian Boyd received the $22.4 million settlement in full. He paid off the mortgage on the Flatbush apartment. He paid Frankie back for every second job and every skipped vacation and every bill she paid alone while he fought a case the world told him he would lose. He reopened Boyd Creative. He hired back his 12 employees. He finished Invisible Labor, the real one, the one he built, and it premiered on a major streaming platform to critical acclaim. The series was nominated for a Peabody Award. Luke Boyd went back to school, not community college, Howard University. Full scholarship, funded by a grant from the National Association of Black Journalists, which had followed the case and created a fellowship in Julian's name for Black independent filmmakers. On the day Luke left for Washington, D.C., Julian drove him to the airport. They sat in the car for a few minutes before Luke got out. "Dad?" "Yeah. I need to tell you something." Julian looked at him. "That night at the law firm, when I heard those attorneys talking about the recording." Luke paused. "I was scared. I didn't know if it would work. I didn't know if the judge would read it. I didn't know if they'd come after me. But you filed it anyway. I filed it because you taught me something. You didn't teach me law. You didn't teach me how to fight a billion-dollar company. You taught me that when somebody takes what you built, you don't walk away. You pick up whatever you've got, even if it's a mop handle or a $45 form, and you walk into the room where they don't expect you. Julian's eyes were wet. He didn't wipe them. I taught you that? Every night at that kitchen table. You didn't know it, but I was listening. Julian reached across and pulled his son into a hug. They stayed like that in the car at the departures curb until a traffic officer tapped the window and told them to move. Luke grabbed his bag. He opened the door. Then he turned back. One more thing. What? I mopped those floors for 14 months. I want you to know, I would do it again. Julian watched his son walk into the terminal. He sat in the car for 5 more minutes. Then he drove home. Byron Frost spent $10 million on lawyers. He hired 8 attorneys, 3 paralegals, and a communications strategist. He filed 23 motions in 18 months. He buried a recording. He signed a false certification. He stole from a man with 12 employees and an office above a dry cleaner, and he assumed that money would do what money always does, make the problem disappear. He was almost right. Julian Boyd was 3 months from bankruptcy. His wife was working 2 jobs. His son had dropped out of school. The case was dying, the way these cases are designed to die. Slowly, quietly, expensively. But one night, a janitor heard something he wasn't supposed to hear. And instead of looking the other way, instead of protecting his job, instead of telling himself it wasn't his fight, he walked into a courthouse in his work boots and filed 1 piece of paper. 3 pages, $45, and a billion-dollar empire cracked. The most expensive legal team in the country couldn't stop it. Because you can't outspend the truth when someone is brave enough to write it down. Some people inherit power, some people buy it, and some people file it, 1 page at a time. Click the video on your right to see the 3 other corporate espionage cases where self-representation destroyed billion-dollar companies, the legal loopholes they exploited, and the one statute that changes everything. You will see the patterns these strategists use, the mistakes their opponents make, and the exact moment when the trap